You've probably heard of it, right? Black's Law Dictionary. If you've ever been in a legal debate, or heck, even just watched a courtroom drama, you know the one. It's that huge, heavy book you see on every lawyer's shelf. It feels like the final word, the ultimate authority on what all that legal jargon actually means. But what if I told you its greatest strength isn't what most people think it is at all?
We've all seen this happen. You're in some heated discussion online and somebody triumphantly whips out a definition from Black's. They post it like it's the ultimate trump card, the mic drop, and the conversation's supposed to just end there, right? Case closed. I mean, it is the dictionary of law after all. But this whole idea brings up a really critical question. When we're talking about what's legally binding, what the law actually is, can a dictionary really be the final word? The answer is a clear, simple, and resounding no. And the reason why, well, it gets to the very heart of how our entire legal system works.
So, let's do it. Let's put that common belief on trial. We're going to dig into this gavel-slamming myth that a dictionary definition is somehow the same thing as the law itself.
And here's the verdict. Plain and simple, Black's Law Dictionary is not the law. Full stop. It's an absolutely fantastic guide and essential tool, but it holds zero legal authority on its own. The reason for this big mix-up comes down to a really crucial distinction: the difference between primary and secondary sources.
Okay, so to really get why the dictionary isn't the law, we've got to wrap our heads around this idea of primary versus secondary legal sources. Honestly, this one concept is the key to the entire puzzle.
Think of it like this. Primary sources are the law. They're the actual documents that create and establish the rules we live by. We're talking constitutions, laws passed by Congress, and the rulings that judges make in actual court cases. Now, secondary sources, those are materials about the law. They explain it, they analyze it, they summarize it, and guess what category Black's Law Dictionary falls squarely into? Yep, it's a secondary source. And here's the best part. You gotta love the irony here. Black's Law Dictionary literally defines itself as a secondary authority. This quote is right from its own 8th edition. It's telling you, right on the page, hey, we explain the law. We don't make it. It's a guide, not the rulebook. This analogy just drives the point home perfectly. Citing a dictionary to a judge? Yeah, it's not gonna fly. In a real courtroom, they need the primary sources, the actual laws and the previous cases. The dictionary is a fantastic place to start your research, to understand the landscape. But it's never, ever the end of a real legal argument.
Okay, so if it's not the law, then what is it? And where did this legendary book even come from? To really get its true value, we have to go back to the beginning. This dictionary has a long, long history. The first edition dropped way back in 1891. But a really pivotal moment, a game changer, came in 1999 with the 7th edition. That's when Brian A. Garner took over as the editor-in-chief, and he totally revolutionized the whole project. And it just keeps evolving, with the 12th edition just hitting shelves in 2024. And the founder, this guy Henry Campbell Black, was a force of nature. He was a deeply respected scholar who wrote these dense legal books called treatises on just about everything, from big-picture constitutional law all the way down to the nitty-gritty of regulations on intoxicating liquors. So from day one, this project had some serious credibility baked right in.
But the dictionary we know and use today, that was really forged by a completely new vision, one that took it from just being a collection of definitions and turned it into a true work of scholarship.
Yeah, Brian Gardner's arrival was a massive shift. Before he took over, the dictionary had kind of become a compilation of definitions just pulled from different court cases over the years. Garner and his team came in and treated it like a serious academic project. They researched every single entry from scratch, focusing on absolute precision and clarity.
And this quote right here, it gets to the very heart of his philosophy. Instead of just grabbing a definition from some random judge's opinion in a case, Garner's team made a point of quoting from treatises written by the top experts in that specific legal field. His logic was simple. A scholar who spent their entire career studying, say, contract law, is going to give you a much better definition than a single judge in a single case. And this incredibly meticulous approach, it led to some pretty fascinating discoveries. For instance, because they were re-researching every single entry, they managed to fix a tiny little mistake that had been hiding in plain sight for almost 100 years.
So get this, way back in a 2nd edition, in 1910, a typo happened. The word vitilitigate, which basically means to argue in a really quarrelsome way, was accidentally printed as vitiligate. Just a simple typo, one syllable dropped.
But here's the crazy part. That typo was just carried over again and again through the 3rd, 4th, 5th, and 6th editions. For 89 years, nobody caught it. It wasn't until Garner's team went back to the original sources for that 7th edition that this nearly century-old mistake was finally found and fixed. It's just a perfect example of how detailed their work is.
Now, all that deep scholarship isn't just about fixing the past. It's about making sure the dictionary is a living, breathing document that actually reflects the legal world as it exists today.
The dictionary has to keep up with our crazy, fast-changing world, and it does. Just look at some of the terms that have been added in recent editions. Porch pirate, doxing, deepfake, ghost gun. I mean, these aren't just new words. They represent entirely new legal frontiers that didn't even exist a decade or two ago. And the work is nonstop. The 2024 edition alone added 2,500 new terms and definitions. Just think about that. That's a massive amount of work just to stay current.
So what's the result of all this ongoing effort? Well, the current edition now defines over 70,000 legal words and phrases. It is, by far, the most comprehensive law dictionary ever put together in the English language. So let's bring this all home. The big takeaway is this. Black's Law Dictionary may not be the law, but that doesn't make it any less valuable. Its real power isn't as a rule book to win arguments. Its power is as an essential, indispensable guide that helps all of us, lawyers and non-lawyers alike, understand the incredibly complex language of the legal world.
And that really leaves us with a final thought, doesn't it? In a legal system that is built from the ground up entirely on words, where precision and a shared understanding are absolutely everything, what is the true value of a single, trusted resource that helps everyone speak the same language? At the end of the day, providing that common ground might just be the most powerful role it could ever play.